Member for Bruce. The question is that the document be noted. I call the member for Goldstein.
Thank you, Deputy Speaker. And I think there's nothing better than the opportunity to speak about the importance of free speech and to follow the diatribe before, because the member there has a privileged right as a member of this place to be able to get up and say whatever he likes, but he won't afford the same privilege to others. And in fact, he uses the opportunity in the platform he has been given to judge people based on the colour of their skin and not the content of their character. Isn't that exactly what he claims? He claims he's trying to stand up against. That is the problem. At the heart of the ALP is that they play identity politics, they focus on points of division rather than points of unity, they make a mockery of universal human rights, and they ought to be ashamed of themselves. Deputy Speaker, I welcome this report and the recommendations that have come out of the Parliamentary Joint Committee on Human Rights. And I do so because I'm a Liberal. I'm a Liberal. And we believe in free speech. We believe in free speech because the foundation of a free society, democracy and of dignity of the individual. And if you ever want to bring that into question, go and read Sir Robert Menzies, the great Sir Robert Menzies, and particularly his second and third Forgotten People speeches, where he spoke explicitly about free speech and how it is not just at the core of liberalism because it focuses on individual dignity, but also because it is central to the operations of a democracy. And that is why we must preserve it, and that is why we must protect it. But I acknowledge that there are serious concerns that have been raised by people who support either the current version of this law or equally some form of reformed law into the future, which is that we must always protect people against harassment in society. We must. Everybody, if we are to preserve their equal dignity, has to be able to live their life in freedom and free from intimidation and harassment of others. And frankly, I don't think it should be limited just to issues of race. I think exactly the same principle should apply to people based on their gender, their disability, their sexual orientation, or any other issue or attribute that's irrelevant, because people have to feel safe. And that's what I said in my submission to this inquiry, and that is the Liberal way. The important thing about this report is that it actually provides a way forward. The previous speaker was such a hypocrite in the way that he indulged in...
The member for Goldstein will resume his seat. Member for Scullion.
The member for Goldstein ought not reflect on a member and he should withdraw.
For
the sake of brevity and expediency, I will withdraw.
Order. Order. Just order. Member for Scullion. I'd ask the member to withdraw.
I shall therefore withdraw, Deputy Speaker.
Thank you. Member for Goldstein has the call.
But I would stress again that the previous speaker got up and said the report said that there was no issue with the law and it didn't need to be changed, and then talked extensively about how he supports the recommendations that recommend changing the process in the law. With all due respect, I think that there is an inconsistency. I'm sure I'm allowed to say that. And I think that what we should be doing, as the member for Barrow has said in this place only before the recent division, is to look at how we can reform the law in a practical and sensible way, particularly around supporting Recommendation 3 and its option of removing offend, insult and humiliate for the terms of harassment. And I've just made the case why. Because the law should treat everybody equally, and I make no apology for standing up for that fundamental principle of liberalism. And that's what I said in my submission to the inquiry, that we should set a standard that applies to people consistently. And I also support it because it was the foundation of the introduction of the law in the first place. And people forget this. Often Labor and other members in this place or others outside this place remark that this 18C was introduced and was preceded by 3 independent inquiries that recommended the current law. That is fundamentally untrue. Section 18C was introduced in 1994 by then Attorney General Michael Lavarch. Lavarch said 18C was necessary because, quote, 3 major inquiries have found gaps: the National Inquiry into Racist Violence, the Australian Law Reform Commission's report into multiculturalism, and the Royal Commission into Aboriginal deaths in custody. And it's true, there were 3 inquiries. But before they're used as a justification, people should actually read them. The Royal Commission didn't recommend the current law. It recommended a law prohibiting, quote, racial violence, discrimination or hostility. The ALRC inquiry recommended, quote, making incitement to racist hatred and hostility unlawful. Even then, though, one of the ALRC commissioners dissented, saying that, quote, in a democratic and pluralist society, freedom of expression is of special importance, which may necessitate tolerance of obnoxious and hateful views which do not incite violence. Critically, the Human Rights and Equal Opportunity Commission's inquiry into racist violence recommended a civil offence against incitement of racial hostility, an express prohibition on racist harassment, as well as a federal criminal offence against racial violence. The Commission also recommended the creation of offence of incitement to racial violence. None, and just for the sake of it, because there were 3 inquiries, none recommended making offensive, insulting or humiliating speech unlawful. That's not just my conclusion. That was actually the conclusion of the Parliamentary Library in its Bill Digest, where it identified that, quote, the Racial Hatred Bill 1994 is in some respects completely contrary to the recommendation of these reports. The Digest went on to say that the standards set by these inquiries involved a high threshold of serious conduct, yet 18C establishes a civil offence with a significantly lower threshold. These 3 reports recommend a law rightly focused on harassment, hostility and violence, which is at the core of the recommendation that's just been handed down in recommendation 3 as one of its options, to actually go back to what Labor thought they argued for in the first place but got wrong. In arguing for the law at the time, the then Attorney-General also said that, quote, the bill places no new limits on genuine public debate. Australians must be free to speak their minds, to criticise actions and policies of others and to share a joke. The bill does not prohibit people from expressing ideas or having beliefs, no matter how unpopular the views may be to many other people. And respectfully to the member who's interjected, that's the former Labor Attorney-General who said that, Michael Lavarch. Again, not me. Similar sentiments were echoed in a 1994 article in the Age newspaper arguing for the law. And according to its advocates, quote, most Australians would sympathise with the aims of the bill, as I do, namely to control racist violence, threats and harassment. We can be sure that that was true then, and it remains true today, including by all of the people who support a change in the law, a constructive change in the law. They then went on to say that, quote, the law will apply to the skinhead on the street yelling racist names and other insults at an Asian man or a woman in traditional Islamic dress, not newspaper articles or anti-immigration pamphlets, Deputy Speaker. Now, any objective assessment says that that test has now been proven to be false, even if it has been unintentionally. And it may appear the insidious nature of the law has been revealed only in recent cases, but that's wrong. It was controversial when it was first introduced. A speech worth reading from the time, and as the previous speaker said, have one of those moments sometimes, Deputy Speaker, you don't think you're ever going to have, where I am going to recommend a speech by a member of the Australian Greens. She said, Australian Greens Senator Christabel Charmette said at the time, Shamrat, apologies, see, there you go, everybody can make errors. She said the broad scope of the law would, quote, create a crime of words, taking the legislation across a certain threshold into the realm of thought police. That's stronger than most criticism raised by 18C's critics today. How far the Greens have truly fallen. It's in its present form that 18C has more in common with anti-blasphemy laws in theocracies than it does, frankly, with other federal laws dealing specifically with public speech. And when you put it into context just how bad it is, and there are so many things I have yet to say in the time, Deputy Speaker, it becomes clear that it's a complete aberration because there's no equivalent provision on the basis of people with a disability. There's no equivalent provision for people on the basis of their gender or sexual orientation. And the reality is, and I've used examples like this before, which are rooted in reality, where we established a test around harassment, I'm quite relaxed about that. Because the reality is, there are times where people get attacked on the basis of people's culture in other minority groups, Deputy Speaker. And when that happens, 18C creates a legal shield for them to not be able to stand up and call out other people's bigotry. And this, in the end, is the frustration I have. Let us have a law that applies to everybody. Let us have a law that respects everybody equally. Let us not create an environment where some people enjoy special legal privileges where other people do not. In the end, it is time to cut the cancer out in the middle of this law and replace offend, insult and humiliate, and replace it with harassment so we can have a Racial Discrimination Act that enjoys the confidence of the whole Australian public.
Order. I thank the member for Goldstein.